Welcome to freedivorce.com.
This is Christina.
And this is Ed. Today we're going to talk about how to serve your court papers on your spouse. We're assuming you've already filed your petition and summons, and if you have minor children, your UCCJEA declaration with the court. When you file those papers, the court clerk should have kept the originals and given you back filed-endorsed copies of each court form. You should have 2 sets of filed-endorsed copies. One set is for your records, and the other set is for you to serve on your spouse.
So, Ed, exactly what papers are you going to need to serve on your spouse?
Well, it depends on whether or not you have minor children by your marriage. If you don't have minor children, you're going to serve your spouse with 3 court forms. Those consist of filed-endorsed copies of the summons, which is the FL-110, a filed-endorsed copy of the petition, which is the FL-100, and a blank response form. And the blank response form is FL-120. Now, if you have minor children, then you need to serve 2 additional documents. You need to serve a filed-endorsed copy of your UCCJEA, which is the FL-105, and then also a blank UCCJEA form.
Can our listeners find blank copies of the response FL-120 and a blank UCCJEA in our court forms database?
Yes, just pull up the blank forms from our database and print them.
How do I properly serve my spouse with the court forms?
There are 2 common ways to accomplish service of process. One way is the personal service method, which is when you have someone personally hand your spouse copies of the summons, petition, and the blank response, and then fill out a proof of service of summons form. Now, the proof of service of summons form goes by FL-115. The second method of service of process is to use a Notice and Acknowledgment of Receipt form, and that form is FL-117.
Let's start with the personal service method. How does that work?
Well, the personal service method is the simplest method, and it's the method we recommend using. Again, the personal service method is when you have someone hand the summons, petition, and blank response to your spouse. You cannot serve the papers on your spouse yourself because you are a party to the divorce actions. And parties to divorce actions can't serve papers. You need to have someone else that is at least 18 years old serve the papers. Now, you can have a friend do this, or you can have a relative hand your spouse the papers. Either way, it doesn't matter, but you can't serve the papers.
Should I hire a professional process server?
Well, hiring a professional process server is an option if you don't have a friend or a relative that is willing to serve the papers for you. A professional process server is going to charge you around $75, sometimes a lot more, particularly if they're going to have to make multiple attempts to get the paper served. If you want to use a professional process server, what you can do is you can Google process server and find a list of process servers in your area. Now, if you hire a professional process server, you want to ask them in advance how much it's going to cost. If your spouse is cooperating with you, there should be absolutely no need to hire a professional process server. Just contact your spouse. Find out when it'll be convenient for them to be home and receive the paperwork. Then have a friend or a relative serve the papers.
What do I do after I have a friend or a relative serve the papers on my spouse?
Well, after the papers have been served, you want to go to our court forms database and fill out the proof of service form, which again is FL-115. After you fill out the FL-115, have the person that served the papers date and sign that form.
What is the second method that can be used for service of process?
Well, the second way to serve your spouse with the summons, petition, and blank response is to use the form known as a Notice and Acknowledgment of Receipt, which again is the FL-117. With this method, your paperwork is mailed to your spouse, and your spouse signs a court form acknowledging that they received the paperwork. You start by going to our court forms database and filling out the FL-117. This form is something that you prepare, but your spouse signs. Now, after you fill out the FL-117 form, you cannot mail it to your spouse because, again, as a party to the action, you cannot serve the summons and petition. You need to find a friend or a relative that is at least 18 years old that is willing to date and sign the FL-117 form and put the form, along with copies of the summons, petition, and the blank response, in the mail addressed to your spouse. The friend or relative signs the form on line number 3, which is located in the middle of the form. When the paperwork is mailed to your spouse, you also have to include a stamped, self-addressed return envelope. So when your spouse receives the form, he or she dates and signs the FL-117 near the bottom of the form. Then your spouse mails the signed FL-117 back to you in the stamped envelope that you provided. They have now been served.
After your spouse sends you back the signed FL-117 form, what do you do?
If you use the Notice and Acknowledgment of Receipt method, you will still need to complete the Proof of Service of Summons form, which is the FL-115, after your spouse sends you back the signed FL-117. On the FL-115, instead of filling out the information for Box 3A, which is the part you would fill out when you use the Personal Service method, you will instead fill out the information for Box 3C, which is for service by mail and using the Notice and Acknowledgment of Receipt method. After you fill out the FL-115, you are going to attach to the FL-115 the completed FL-117.
So, does our court forms database include completed versions of FL-115 and FL-117 using both the Personal Service method and the Notice and Acknowledgment of Receipt method?
Yes, our forms database has not only blank versions of the FL-115 and the FL-117, but also completed versions that you can print and look at and use as examples.
Okay. After I have filled out the proof of service paperwork, what do I do?
After you've completed your proof of service paperwork, you want to make 2 copies and then file the original and copies with the court clerk. Again, the clerk will keep the original and give you back filed-endorsed copies.
After my spouse has been served, does my spouse need to fill out the response form, FL-120, and file it with the court?
Well, that's going to depend. After your spouse has been served with the summons and petition, if the two of you are able to work together and reach a negotiated settlement on all issues, well, then your case can proceed as an uncontested divorce or a default with an agreement case. And in that situation, there is no need for your spouse to fill out his or her response form FL-120 and file it with the court. If your spouse wants to fill out the response, which is the FL-120, and file it with the court, then your spouse will have to pay the first paper filing fee, unless he or she qualifies for a fee waiver. Now, if you and your spouse are going to be able to reach a negotiated settlement so your case will be uncontested, there's no need for your spouse to file a response with the court, and there's a way for your spouse to avoid the first paper filing fee. The method for your spouse to avoid paying the first paper filing fee is explained in a later video about processing a judgment as a default case with an agreement.
Wait a minute. If you look at the first page of the summons, it tells the other party that they have 30 days after being served with the summons and petition to file a response with the court. Otherwise, the court can make all kinds of orders against that party. Can you explain that?
Well, if your case is going to be an uncontested case, your spouse does not need to worry about the notice printed on the summons that says your spouse has 30 calendar days after the summons and petition are served in which to file the response. You and your spouse can ignore that 30-day time limit if your case is going to be uncontested. The court won't do anything on its own after the 30 days passes.
What if my case is going to be a contested divorce? Does my spouse need to fill out and file the response with the court within a 30-day period?
Yes. If your case is going to be a contested case because you and your spouse are not able to work together and reach a negotiated settlement, then the 30-day rule is going to apply, and your spouse should certainly file their response with the court within the 30 days. Otherwise, you could take their default. And if you take your spouse's default, then the court can and will make orders affecting your spouse's rights regarding property, custody, and support.
If my spouse wants to file a response with the court, how do they do that?
Well, if your spouse wants to file a response, they can use our website to do so. The response form, the FL-120, is nearly identical to the petition, which is the FL-100. Since the response is nearly identical to the petition, the same video guide instructions we provide in our initial filings video guides on how to fill out the petition can be used by your spouse to fill out his or her response, as well as his or her UCCJEA declaration. This has been a presentation by freedivorce.com.